Now, without further delay, I take this opportunity to invite Professor Dr. Mohammed Abdul Wahal to introduce our keynote speaker. To many, Mohammed needs very little introduction. If I were to read Mohammed's impressive CV and credentials, it will take up the rest of the time for the lecture. So I'll simply say that Mohammed is recognized as a world leader in international dispute resolution with considerable expertise and experience in international investment, international commercial arbitration, Islamic Ciarb, construction, energy, telecommunications, finance, and online resolution. He's a professor at international arbitration and private international law at Cairo University, the founding partner and head of international arbitration and construction and energy at his law firm. I'm embarrassing him now. And of course, a member of Ciarb's board of trustees. So, Mohammed, thank you and welcome.
Thank you so much, Catherine. Thank you. Thank you very much.
Hi, Louis.
Today is really about our keynote speaker, and we're delighted and privileged to have Professor Jan Paulsson with us today. Now, it's a colossal task to introduce someone like Jan, because there are, practice, profession defines people, but there are people who define a field. And Jan is one of those people that have only been a leading light, but the practice, standards, principles that we studied, that we teach, he has been shaping them along with other few in the world of international arbitration over the years. Jan Paulsson is known to everyone in the field. Sometimes they tell you, the background, you hand a card, but the name of a person is sufficient. And Jan is one of those people. Jan was a founding partner among others, with 3 crowns. He retired in 2020. He's currently a judge of the Court of Cassation at the Kingdom of Bahrain. He is formerly the head of international arbitration and public international law at Freshfields for a number of years. He's now a professor emeritus at the University of Miami. He is the president, formerly, of the International Council for Commercial Arbitration, ICA, between 2010 and 2014. He has been the president of the London Court of International Arbitration previously, a previous vice president of the ICC Court of International Arbitration, a member of the Permanent Court of Arbitration since 2008 till today, a former president of the World Bank Administrative Tribunal, a former president of the European Bank for Administrative Tribunal, a former judge of the International Monetary Fund Administrative Tribunal, a past president of the Organization for Economic and Cooperation Development Administrative Tribunal, a former member of the Ciarb Court of Arbitration, and a former member of the board of the American Arbitration Association, and is on the panel of ICSID from 1998 till date. This tells you that name it, and he has done it. Literally. Cases, ad hoc, institutional. The cases that are on record that have defined principles, whether in commercial or in investment arbitration, Jan has been involved in it in one capacity or the other. His books has far reach across the globe and has resonated with academics and practitioners alike. To name a few, The Idea of International Arbitration, The Idea of Arbitration by Oxford University Press, The Unruly Notion of Abuse of Rights by Cambridge University Press, Denial of Justice in International Law, again, Cambridge University Press, Guide to ICSID Arbitration by Kluwer, the International Chamber of Commerce Arbitration, Oxford University Press, International Commercial Arbitration by Foundation Press. When you look into the case law, whether you're an academic or a practitioner, you cite cases, you look at awards, Jan's input is there. Jan, we're privileged to have you with us in person. He will be delivering a lecture on the blind corners of international arbitration, and the floor is yours. Thank you very much for joining us.
Thank you very much for that welcome. I stand here looking at a beautiful garden in Oxford. It will distract me, and if it distracts the speaker, I can only imagine that you're very tempted to be distracted as well. I'm very pleased to be with you today. I thought, actually, I was startled when I saw Blind Corners of Arbitration, and it actually rang a bell. When I was asked to give this talk, I was also asked to indicate what the subject would be. And as I all too often do, I neglected what I was requested to do, and I never did so. So this was, what do you call it, a placeholder. Now I remember it, I saw it, it was a placeholder, and now I see it again. Blind Corners of Arbitration. So there I am, and all I can say to you is that it seems to be a self-fulfilling prophecy. Blind Corners of Arbitration, you never know what's next. Me the first. I thought I might give a few reflections on giving speeches. It's something that puzzles me sometimes. Why do people want to listen to speeches about law? You can read this stuff and go immediately to the question you want answered and not have to hear all the introductory stuff and building up to the subject. And why is it necessary? I had the sobering experience once of really trying to push the envelope and be extremely erudite. I had the undeserved privilege of being named the Centennial Professor at the London School of Economics. That lasts for about 2 years. And it's very prestigious, and you are, I thought, I was expected to make a contribution which was extremely erudite and academic. And I prepared myself very carefully. Mohammed will recognize when I say that this was part of my long-standing debate with my friend Emmanuel Gaillard, who had a different conceptual view of arbitration than I did. All abstract, all theory, all very convoluted, circumambient, and oblique. Just the way you should do it when you're a big head. And it was 50 minutes long. I really prepared it extremely carefully. And looking back at it, I wondered, well, I mean, that's very hard to follow even if you're reading it. And it's at London, it's the LSE, and there were about 300 people there, and none of them left, and they seemed to be extremely, extremely polite. And my conclusion to that really came a few years later, many years later. I happened to Google myself. And there was a YouTube of that lecture. So I thought I'd have a listen to see what I looked like and sounded like. And oh my God, I just couldn't stand it after about 5 minutes. I just didn't understand what I was saying. It was so abstract. So we have to be really careful and a bit modest when we sail forth on the high seas of imparting that kind of information. YouTube, you actually have comments? And how many visitors? 1 comment. So this would be 100% of the evaluation of this would be from 1 single person. And the words were as follows. In my opinion, that's it. Whoever it was just didn't have any interest even in putting down what their opinion was. So much for that. There's another way of doing it, and perhaps we can do something of that today. Many of you may be familiar with the MIDS program in Geneva, which is a graduate program in international arbitration, which lasts for a year. I've given the part of the general course there a couple of times, and it's a great pleasure, especially if they do it at the right time of year and you're there next to Lac Léman and enjoying that ambiance. And the students are always very stimulating, and it's great stuff. 1 year when I hadn't really been planning to go there, I was called and asked by the director if I wouldn't mind coming up and giving the last lecture of the year the next week. And I said, I don't think I can do that because I have a hearing coming up, and the hearing lasts until the day before this is going on, and I'm completely immersed in this case, and I can't really prepare for it. And the response to that was, "Oh, great." I thought, no, really, I don't have any time to prepare for it. I don't think we're communicating here. He said, "Oh, well, that's really, really very good." I said, "But I'll be tight." What do you expect me to do? He says, "Nothing at all. I don't have time to prepare." Well, don't prepare. That's the point. We don't want you to say anything until you're asked to say something. And the students know something. They've seen the things you've written, or they know the subjects you're used to talking about. So you'll just stand there, and the students have an hour, and they can just ask questions because they've been thinking about arbitration for 1 year. This is, to me, the most rewarding lecture I've ever given because the students all came armed with their questions. Some of them probably were a little bit nonsensical, out of the blue, but most of them were spot on. Really basic things, fundamental things that you need to have ready answers for because they're basic, and if you don't know the basic stuff, why are you getting lost in abstractions? So that strikes me as something that should be followed more often with the participation of the students who were unabashed in the questions they asked, and that opened my mind to what people at that level of their approach to arbitration are really interested, as opposed to what I imagined they might be interested in. I'll conclude this review of speaking duties with something that happened to me the day before yesterday. My mentor in practice, Laurie Craig, whose name may be familiar to some of you, passed away a few weeks ago, and there was a memorial service for him in Paris, and I was asked to say a few words because I was his lieutenant for many years. And it was a nice occasion, and I was really worried that there would be a hitch in my voice at some time. But there wasn't, and it was a lovely occasion. And even there was quite a bit of humor in it. I've been told that there were 3 speakers, and the first was one of the sons of the departed, and the second speaker didn't show up. And there was a call saying that he was in a cab coming in from the airport and would try to make it as soon as possible, but it was beyond his control. So I was told, well, then you go. But I had planned to speak third, and the end of my talk in my mind was concluding words, and now we go out on the terrace and something special for the end of it. But what could you do? So I began to give my talk, speaking to the family, speaking to all the people gathered there who obviously were a circle of friends because we had loved this man, and that's why we were there. And then sort of 2/3 of the way into my speech, I was standing everybody was standing. A door opened, and a troop of very impressive-looking people walked in. And it was the second speaker with a dozen, I think, very, I don't know how to put it, serious-looking people surrounding him. And I looked at him and recognized him. And I will be the only one of 3 people in this room who instantly knows who I'm talking to. Nanado, Akufo-Addo, Sarah and Anne-Marie. He was in Paris the day before yesterday. And the reason I want to mention this is this. My first job as a lawyer was in Paris. The fellow in the next office to mine was a young man from Ghana who had studied in Oxford, taken his degree, and somehow got a job in a law firm in Paris and was sitting in the office next to mine. And we had the same boss, Laurie Craig. And that's why the president of Ghana had made it up to Paris and made it just in time to interrupt my speech. And in his, quite appropriately, he became the last speaker. The internationalization of the practice of law is very interesting, and it was going on back then. We're talking about 1975, my first day on the job. What do you suppose he was doing? Aircraft finance. Where was he spending all of his time? In Helsinki, His number one client was Finnair. Nothing to do with Africa. So these are the adventures that we have in international practices. It's one of the reasons I think it appeals to so many of us in so many ways. I want to mention three topics today. One thing is a concern I have. I've been involved all my life in international arbitration. I applied my mind to this once long ago, and I try to think, have I ever been involved in a national arbitration? Could I think of a single case I was involved with where both parties were of the same nationality? And I couldn't. I really believe I have never, ever been in a case where both parties were of the same nationality. And that creates certain interesting things which I hope you will accept to hear about as I continue. So that's international arbitration, but it comes in many forms. And I'm concerned now that in the national environment, that we have not just a difference of the way practice might develop in different hemispheres or even in different nations, but it may even be the case that arbitration itself develops different ethos depending on which type of arbitration you're doing. In some types of arbitration, you have less issues of procedural gamesmanship. People sort of want to get on with it, and they just want a result, and there isn't endless discussion about fine points of conflicts of interest and failures of disclosure and the like. People tend to know each other, and so you have very, very different feeling in certain arbitrations as opposed to others. That's something of a concern of mine, because the result of that can be that you have the emergence of different understandings as to what the rules might be. And those who operate in a particular environment where people tend to know each other, or even if they don't quickly recognize each other as practitioners speaking a certain kind of language and with certain expectations, and don't want to be known for being sort of a bad egg, that will be very different from the kinds of very harsh arbitrations where two parties are involved who will never have any future dealings and who are trying to achieve the best results with great pressure to do it by hook or by crook, and you have difficulties that arise in some circumstances which cause people to want to make more rules to stop that. And that may have the effect of stultifying the arbitrations which go on much easier, where those questions don't arise very often. That's to be very much regretted, and I don't quite know what to say about it. I regret, in my case, when I started out, I used to see a lot of architects, engineers, so from time to time, maritime people, involved in some way in cases that I was doing. And those areas have all gone. Some of you may remember some names from that time in construction arbitration. There was a gentleman named Ray Turner. There was a man named Norman Royce, who was an architect, who was one of the most elegant people I've ever met. He taught me remember two things he said. He was a very elegant man, and he had a way of coming up with just the right quip. One pretty good one was, the only thing we learn from experience is that we don't learn from experience. I thought that was pretty good, but here's a better one. Experience is the comb life gives us when we lost all our hair, he said, with reference to his own thing. So this is something I think we should be attentive to, and perhaps a little bit humble about, that the particular field we might be in has certain practices, certain rules, certain expectations, which are not necessarily universal. And you might come up against somebody who actually operates in a more innocent environment than yours, and whose practice is, fortunately for that person, is with respect to those things, more convivial, more accepting, more trusting of the opponent. and it's unfortunate if that is lost, and it's unfortunate if you're constantly having to devise new rules to make up for new inventions to frustrate the process. I want to talk about a couple of things. I want to revert to a subject which I've talked about sometimes in the past, and I've had some more thoughts about it. International arbitration is not arbitration. And then I'd like to say a few things about the clash of cultures, which I think is, in my opinion, is quite misunderstood, and we should try to think about it straight. So, international arbitration is not arbitration. I think perhaps most of you in the room are ready to go with me on this one, but I have a couple of ways of proving it. One is 15 seconds. International arbitration is not arbitration. Do you think a sea elephant is an elephant? The 30-second one is international arbitration can't possibly be arbitration. Because the thing that is most important in international arbitration isn't even relevant to national arbitration. How's that one? In international arbitration, you're concerned about neutrality. In national arbitration, it's a little bit different. And let me get back to that. What's important in international arbitration is neutrality. And that doesn't arise in the same way at all in a national context. And you can have very different attitude towards arbitration. Let's take two countries which may interest you as a matter of surprise. Switzerland and Sweden, convenient, name similar. My country of origin, Sweden, is one where people love arbitration, national arbitration. Jonsson versus Anderson, they love it. I don't quite know why, but if you're a Swedish businessman and you propose a draft contract without an arbitration clause, you'll get an alarmed look. What sort of a person are you? You want to wash our dirty linen in public? I haven't really, I'm just guessing at what the motivation about this, but maybe I know Swedish people a little bit better than you do. I think they're really shy, and they just don't want people knowing anything about their business, and they're very embarrassed that they have a conflict. And so they like arbitration. Switzerland sounds very much alike, doesn't it? Very nice people. You would think they'd be very similar in your dealings. And internationally, these are both countries which are known as being seats of international arbitration. Swiss people don't arbitrate among themselves. Why? I don't know. International arbitration in Sweden, in Switzerland, doesn't even tend usually to involve Swiss parties. I'm challenged on this sometimes, but they say, look, here's a Swiss company. And I say, come on, who are the shareholders, right? And I can't quite tell you why the Swiss are not interested in arbitration, but I think it is because they're perfectly happy with their judges, whose salaries are paid by the taxpayer. And why should they pay it again if they think the judges are okay? And I have noticed that in Swiss judgments, very often the names of the parties are anonymized, which is not the Swedish practice. So maybe that tells you something. So in two national legal systems, very different attitudes toward arbitration. And international arbitration is something which is entirely different because we come to it with this idea of seeking neutrality, which is really not of relevance in the national framework in the sense of just trying to find something which operates fairly with parties who come with different expectations. So that leads me to the clash of cultures. I think it's misunderstood in many ways. Sometimes I think that most of the time, the expression is misapplied. There isn't any generic clash of cultures. The same party can have extremely different attitudes depending on what its role is in an arbitration. So on that basis, you would say that the clash of cultures is just a clash. There's a clash between claimants and respondents. Claimants want efficient justice. Respondents want due process until the cows come home. There's a clash, and depending on where you're sitting, you might be acting as an advocate in very different ways depending on the type of party that you are representing. And hence, I think the idea of imagining, this is good news, imagining that the world is filled of different nationalities, different cultures in the sociological sense, who don't get along, I really don't think so. Somebody who hasn't been paid and is a claimant will really have the same attitude no matter where that business person is from in the world, and want efficient and final determinations. There's nothing particularly surprising in that. So the clash of cultures should be understood as something very different. Simply clashes of interest and a search for neutrality and a balance between efficiency and due process, which really doesn't depend on the national origins or the religions or anything else of a sociological nature. I think this is quite misunderstood. Something very important, and Mohammed, I think you will agree with me on this, is an old story of, not a story, something from the pages of history of arbitration. In the 1950s, in the Gulf, what we call the Arabic Gulf, you had in the 50s, in the course of the 1950s, the laws of the various states in the Gulf had tended to become relatively uniform, or very uniform, copied on the Egyptian Civil Code, which in turn was but influenced by the French Civil Code. These are civil law countries. The Gulf, on the south side, was administered by the British Empire, capital of which was in, does anybody know? Bombay. The Secretary of State of the Empire was in Bombay, and the resident, the most important political agent of the British Empire, actually lived in Bushire, in what was then Persia, and that was sort of the British administrative responsibility under treaty, or right under treaty, to administer the external affairs of the various sheikdoms, which subsequently have become states. So that was the way the setup was in the 1950s. In principle, these countries had become civil law states, but that didn't mean very much. The populations were extremely small. The administration tended to be handled by British officials. So when the local population itself had disputes, they tended to seek justice in a very traditional way. Some of you know exactly where I'm going. A series of arbitral awards rendered in important disputes between Arab parties and parties from the West. And some of these contracts turned out to be relatively large. And the contracts tended to be drafted in English. Picture looks extremely different today. There's no difficulty in finding English speakers in the Gulf today. So you had a series of cases in which British judges were impaneled as arbitrators to sit in arbitrations in the region, but supposedly, I haven't seen any sign anywhere of their realizing that they're supposed to apply a civil law, perhaps because it wasn't put before them. And being British judges, they knew that they were supposed to apply the local law, and so they did. And so you had famous sayings, I won't take them out and quote them. The local sheikh dispenses a purely discretionary justice under a palm tree. Hence, I have no idea what the rule might be with regard to subordinated debentures or something. And therefore, in the absence of any understandable law, I will apply English law. This was very offensive. So then you could be talking about a clash of culture, and it was also terribly unnecessary, and we are way behind that. We are way behind that. And don't take it from me. I hope I'm going to make one legal citation today. Professor Fadlallah, man of towering intellect, Lebanese of origin, French university professor for 20, 30 years in Paris, an extremely erudite person, obviously fluent in Arabic, very well conversant in many laws of the world, and a leading international arbitrator. He gave the Freshfields Lecture in 2008, Arbitration International, the journal. You can look at pages 303 to 318. It's very worthwhile. He said, once and for all, let's go back to those old cases, which come up again and again, and people talk about this clash of cultures and how you have Western arbitrators and lawyers who are arrogant and try to impose their laws and so forth. We've gone so far past that now. The laws of the countries involved have now become sophisticated. You have laws about all kinds of legal transactions, how loan agreements are treated, syndicated or not. It's now been legislated, and there are competent people in the new generations who are there. And yet, there are these echoes from the past. So I looked at those awards, and I found it highly impolitic. He was disturbed by these comments. He said they were so unnecessary. So in that lecture, he took each of those cases and actually looked at them through the prism of what should have been the recognized applicable law. He said, they were right in every case. I would not have decided it differently. Why did they say these things? It was all so unnecessary. So I think that's something that we need to think about and need to apply continuously. So no clash of culture. That shouldn't be a problem. We have clashes. We have clashes because lawyers find themselves in an environment where they're not very effective. It turns out that the language of the arbitration didn't go your way. Well, that's not fair. I don't speak Portuguese. I can't be in this case, and that's very annoying. Your client put itself in a position where the jurisdiction clause made it so that you're in an environment, in a place, or under an applicable law, or under a system of nominating arbitrators that you will not be able to be the star of this show. You don't belong here. You can't be a lawyer in Sweden either, I'm sorry. And you can't be a lawyer in every single arbitration. That's just a clash. That's just with yourself. We can't all be everything to all people in all instances. So a bit of humility on that score. Every international arbitration is not designed to be comfortable and an effective place for an arbitrator, for counsel to do their stuff. Obviously, and that's the problem. And you can't transform that into a complaint about something more important and say that this is unfair. Due process is obviously something else, and due process, that's not a clash of cultures. That's simply people insisting on their perception of the right way to be treated. And again, commercial people have the same demands, have the same expectations, have the same worries, and have the same thirst for neutrality, which is the thing that is above everything else. Ladies and gentlemen, I'm hoping we might go to my Geneva story again, and that you can help me be more interesting in the things that I say by provoking me to think about things that really are on your mind, as I think worked extremely well in Geneva. Mohammed, I don't know if this is something that we can do as a possibility, but I'm very eager to try it and to see if we can proceed on that basis. Thank you.
Thank you so much. Thank you very much. I think it's manageable.
All right.
For one, happy to start that. But I think if we're in the Q&A phase, we have questions from those present in the room, and we will have questions online. Mercy will be managing that. We'll take one and one. I'll save mine for perhaps later on to give people an opportunity. But as Jan has mentioned, please feel free to share your thoughts, perhaps even provoke and challenge as you wish. I think I found very interesting aspects that can be probed more, if I may. So let's start. Any question from the room? Comment?
Somebody has to go.
Absolutely. Jonathan, thank you.
So, Jonathan Wood, President-elect of Ciarb. Jan, always interesting to hear from you, and thank you very much for your presence here today. Clash of cultures, not cultural, but just a clash. But does culture itself have an impact on the process in people's eyes, do you think? I mean, that's a slightly different way of looking at culture. Do you still think that there is a cultural impact on international arbitration?
Well, I couldn't agree more. There are some countries where, even in Europe, I have experience in a number of European countries with arbitration-related litigation. So you end up in the court of countries. And I won't mention them, just to say that I'm just really surprised. And that makes, no lawyer should ever be surprised. Clients don't like it. They don't understand how they get stuck with you since you're being surprised by what happened. You should have told them ahead of time. But I'm surprised that in certain leading European countries, the judge will say, oh yes, there was a witness statement. It's Mr. Jones. Is Mr. Jones here? Ah, Mr. Jones. Okay, you come sit here, and then somebody from the court puts him down there and says, so what did you have to say? What do you have to say about this case? And then the lawyer says, no, that's not. I have a specific question. He says, sure. What do you have to say about the things we heard? And the witness gives well, it depends on the witness. Some are frightened, and others are very loquacious, and they talk. But sometimes they talk for a long while. This particular country I'm thinking of is in Southern Europe. Yeah, they talk for a while. And then the judge says, oh, hold it, enough. And is Madame so-and-so, transcript away. And the judge dictates. I, Mr. So-and-so, he says his name, I declare that, and he gives his version of what I just thought I heard very differently. But that's the transcription of that witness's transcript. So you can imagine if you're in that situation, you feel this is just not the right. I don't agree with this way of proceeding. And we all like the procedures that we're comfortable with. So, I think I mentioned that. Look to who did what in the negotiation of the contract in terms of the way the dispute law was drafted or failed to be drafted, that you ended up in this situation where somebody else than you is required to make some sense out of this and get a good result, because somehow in these countries, justice is usually done there as well. So be a bit humble about that.
Thank you so much. Mercy, we'll take one and one. Is there any online?
Can you hear me? Okay. Well, I'm still waiting for a few to come in. If I might take the opportunity to ask a question of my own. For the Chartered Institute of Arbitrators being a global organization, I was actually asked this question last week at another event of how we balance the interests of those from civil versus common law jurisdictions and how we support our members from that background. I was just wondering what advice you would have for making sure that as a member organization, we're representative of those who come from just a variety of legal traditions.
There has been a great sociological evolution in the core of lawyers who are involved in international dispute resolution. And sometimes I think enormous credit should be given to the exercise of the vis moots. It's the work of one man with the genius idea of saying, okay, all this stuff about different procedures in different countries and different applicable laws and so forth. What are most contracts about? Sales. We have a convention on the international law of sales, which applies in, I think, most countries of the world. So let's every year have moot competitions which invariably involve the application of the convention of the international law of sales, where you have a full code of relevance to, I think, a majority of international commercial arbitrations. To this Vienna moot come thousands of students every spring. It's extremely popular in the spring. I don't know how many marriages have occurred as a result of this. And that sort of also spreads the talent around the world because you have mixed marriage in terms of nationality. And where do those young people want to work? They want to work in this field because it's exhilarating, it's really interesting. It opens perspectives. So they work in firms that are active internationally. I think this could have, if somebody knew how to measure it, must have a measurable impact on an adjustment of the expectations in international law, recognizing that it's not the end of the world if the law applicable isn't the law of your country. Now, when we're talking about extremely intricate cases, where the law of evidence might be different and might be outcome determining depending on which applicable law, of course, that may happen as well. But by and large, I think there's a great evening and a great opportunity from people from small countries with unusual mother tongues that are not spoken by people anywhere else to enter the international field and learn a language or two. You see, again, from the vis moot, it's all in English. So what's the rate of English language advocates in the vis moot winning the competition? If you just take it down, not just first and second place, but all the way down, all over the world. And people who are smart, people who are incisive, people who get the point, can make it and adjust and are competitive and will do the necessary thing to make themselves capable of working in that environment. So I think this is should be a receding problem where something really sticks in your throat as this is absolutely wrong. Well, look at who got you there, and that's probably the person who drafted the contract.
The questions are coming thick and fast now. So we have another question about the effect of unconscious bias on the part of arbitrators. And can we be sure that there is no clash of cultures without considering this, speaking specifically on culture-based or gender-based or racially based preconceived biases that an arbitrator might not even be aware of?
No. We cannot be sure.
Yes.
I thought the no would go wrong.
Yes, exactly. I was going to say. Okay.
We cannot be sure, and we do our best to even it. And I think everybody is susceptible to a danger of unconscious bias. I guess by definition we wouldn't know it, but if we really think about it afterwards, sort of after the event, did I speak too fast? Was I really fair? And I think the important thing is to have trust, or is to select arbitrators with view to trusting people who are modest in their feelings about how right they are about things, because that feeling of being right might be the product of bias.
Right. We have in the room some questions. Sarah first, yes. Sarah, please.
Thank you very much, Professor Paulsson. And I mean, I'm particularly grateful for you also taking us on a sort of, I would say, like a world tour. And maybe I'll share an anecdote with everyone here. Is a few years ago, I was involved in a Geneva seated arbitration between parties who are from a country in the Gulf. And during the cross-examination of one of the witnesses, who was a member of the army of one of the states of the Arabian Gulf, the counsel in question was a female practitioner from Switzerland. And at some point, the witness responded and said, "What was your question, young lady?" Obviously, that did not really fly well with obviously the Swiss counsel, but also did not really fly well, obviously, with a tribunal that was predominantly formed by Swiss practitioners. Now, I wanted to give a little bit that anecdote because perhaps, and of course, we're not getting into the debate as to whether that person, what he said, was correct or ethically correct or courteously correct, etc. I mean, there's obviously a debate. But for example, in certain cultures...
Or whether in his culture that was not an insult.
Exactly, Professor. Yeah. But what I really wanted maybe to commend is sort of the theory that you brought forward on the clash of cultures. And obviously, if we do a little bit of parallelism between political science and international arbitration and the theory of the clash of civilization, which, again, I'm not saying is one which would apply or not, because we know, for example, that French President Jacques Chirac was completely opposite Samuel Huntington's theory that there is de facto any type of existence of clash of civilization, because we are all sort of one world. Now, nevertheless, I'm very tempted to take you back to that theory, and obviously the American political scientist Huntington says pretty much that, you know, the future of wars is not going to be wars between countries, but it's going to be wars between cultures. And as we move forward towards more of a movement of the internationalization of arbitration, there is obviously a movement in tandem going with it, which is the standardization. And we see more and more, obviously, certain guidelines which are being more and more applied and recognized. So there's really a move towards, I would say, more the objectivization of the justice that's being rendered. So my question to you, if I may, is pretty much, will the future of international arbitration play out on a clash of cultures or not, given that push for standardization?
What are the elements of objectivization?
Neutrality.
Neutrality. Okay. Well, I think, in my experience...
General application of law, which is, you know, in the philosophy of law, means that, you know, law should be general and applicable even across all members of society.
International commercial arbitration is the most interesting form of arbitration because every case is different, and yet they all come from contracts, and somehow the combination is a very good one. Just from experience, the fellow who stands up and complains that this tribunal, he tries to form it in such a way that they won't be antagonistic to it. He just complains, this is all wrong, this procedure, you're not doing it right, I made this application and it was on time and I asked for an extension, I didn't get it. That's the respondent.
Yes. So, Athena? Yes.
Thank you. Thank you very much. That was interesting, very interesting. But I would like to take to accept your invitation to go back to Geneva and ask you even questions which are not related to the issues that you have been talking about. Having all these very rich, all these years of very rich experience behind you, and being still a very active practitioner, I was wondering if you can give us a couple of ideas of or examples of things that today in arbitration proceedings perhaps we do wrong. What would be your couple of suggestions about reinventing the way that we run the proceedings in arbitration today?
I think the playbook of preparing for arbitrations has become a bit stultified. It seems to grow and grow. And what I feel is lacking, sometimes it may just be cantankerousness coming with age, but sometimes I wish that an advocate would show his or her quality by being incisive and saying, I dare to go to the heart of it and make sure that it's not obscured by all sorts of marginal things, by just focusing on it and getting it done. That's the star advocate who is able to do that. And I think there's a lot of, I'll be sued if I haven't looked under every rock, and it can be quite tiring for arbitrators to see that sort of thing. So there's no substitute for really hard work, and sometimes the hard work isn't seen by the tribunal because it's all the digging you did and then dismissed. This is not relevant to this is not important for the case, and then have the courage to do it. And if the other side makes the mistake of not following your example, their fine points, because they might have fine points in their case, get drowned a little bit in this mushrooming loquaciousness and endless citations of cases and so forth. There's something about citing every precedent that is relevant in, for example, investor-state arbitration that becomes extremely tedious at some point. You don't want to do any more of these cases because again and again, and you sort of get so used to these cases that you actually forget what they were about because you can't read them one more time. And I think that's that shouldn't be necessary. And I don't think my experience is that it's not persuasive. What's persuasive to the arbitrators is really getting to grips with the facts and the principles. It is unusual that the decisive principle is very complicated, put it that way. Is that the beginning of an answer?
It is one thing I was telling them, is that no matter how complicated the case, how high stakes involved, I told them, at least in my humble experience, I'm yet to see a case where the decisive questions are probably 3 or 4, maximum 5, if even less. It boils down to these core issues. And as you mentioned, the good advocate is the one who can take the tribunal's hand, navigate and walk them through the easiest way to get an award on these matters that are the core issues. Would you agree with that?
Yes, absolutely. And actually, I've been thinking about this lately. I don't know why. It's probably confession against interest or something, admission against interest. I think a lot of lawyers, especially young lawyers, which is normal, worry about the fact that every time they're involved in a losing case, they've done something bad to their reputation. And if you're good, you should really win all of your cases. And this reminds me of one of the great barristers who's no longer with us in London, who was interviewed by a legal publication about his life before he passed away. He passed away in full practice. This is Gordon Pollock. And he was, the young reporter asked him, so, Mr. Pollock, you're the most feared opponent that anybody can have in a case in London. You're the greatest barrister, blah, blah, blah. And you ever lose a case? And what did he say? He was insulted. He was insulted. He said, what? People come to me with the most difficult cases. They come to me with important cases. They're difficult cases, and my opponent is very good because that's also a very good lawyer. And I brag about the fact that I think I win more than half of my cases. And that's my goal. Think of that. Relax.
Mercy?
Okay, we have a question asking about the role of soft law to deal with or mitigate the impact of the clash of culture, approaches, and expectations in international arbitration. Are they relevant or irrelevant, and why?
Define soft law.
I'm not sure if soft law is a contradiction in terms, but I think soft is good. To put people at ease, to talk around the problem sometimes from the tribunal's point of view, to show that there's an interest in exploring all ideas, including the ones that ultimately won't be decisive. And sometimes you do that even though you know it's hopeless as an arbitrator, but you give it a shot and you show you're attentive to it and you're respectful. And generally speaking, the person who advanced that on the spur of the moment realizes, okay, it's not working, it wasn't good, but this is a very nice person and doesn't feel any resentment or any bias. So in that sense, soft, but not because it's law.
Yeah. And people also tend to confuse, or let's say, people talk about soft law, or they have different understanding of what soft law is.
Well,
I mean, guidelines, practices is one thing, and in soft law, assuming it is even law, is another thing. But any other question online, Messi?
Oh, yes, several.
Can take.
Do you want
Shall I
another?
take one and one? Yes. Louis, yes.
Am I going now?
Yes, you are. Yeah.
You want an appointment?
You're not the last, you're the second.
I just want to, Louis Flannery, KC in London, echo, Jan, your reaction to somebody asking you about how you effectively turn a clash of cultures into a marriage of cultures, and the answer is the vis moot, where I have found arbitrators, I have found co-counsel, and I have found employees. I've done exactly what I think you should do at the Vienna Moot. I've recruited there. And I've seen over the 15, 18 years I've been doing it, an amazing shift in standardization, if you like, by use of the convention. And I think we're getting there. In one specific tiny field, I'd like to flatter you with something, because about 20 years ago, you wrote a paper on the difference between jurisdiction and admissibility. 18 years it has taken for it to be cited by an English judge, and it's now been cited 4 times. I might have been responsible for
Thank you.
for the encouragement of it being cited, but finally English judges have woken up to the difference. But it has taken nearly 20 years after the Act has passed for it to happen. But that is part, I think, of the development of arbitration in a positive way. But I can't think of really many negative ways, because of everything you've said is leading to a more positive world, at least in arbitration terms, when everything else is leading to a more negative world in so many ways. But anyway, thank you.
Nice to hear.
Merci.
We have a question. Can you comment on the role of the layman? In other words, those without law training in arbitration.
The what?
For example, laymen, technical experts, and those without law training in international arbitration.
Well, the role of experts is different in different industries and therefore in different types of arbitration. I'm not a construction lawyer. I've been involved in a few construction cases, and it's a challenge. I think I can figure out what the dispute is about and to have some opinions about it, but it takes me forever because I am not versed in the documents. I mean, people who have a knack for it go right to the relevant thing, and I think I have to read it all over, all of it, all the time, and it's difficult. So it really depends. It really depends on the type of cases that you're in.
One of my concerns specifically on construction is the movement towards a de facto delegation of decision-making powers to experts. we tend not to speak about it, and it's easier for lawyers to delegate that, and they tell you the experts. And it is true, there are expertise, and you use them, that's true. But ultimately, it boils down, importantly, whether the tribunal can take a decision. In some cases, the tribunals are unable. They tell you, okay, we get the experts, we get a tribunal-appointed expert, and all this, it becomes problematic. But I agree, it depends on the industry, and it becomes very problematic sometimes.
A decade ago, or maybe a bit more, at an ICCA conference in Rio de Janeiro, a well-known arbitrator named Klaus Sachs proposed a protocol for experts, which was absolutely genial and has absolutely not been followed by anybody that I can tell. It instantly convinced me. What he said was that if parties have recourse to experts, they all swear that they're objective and that they have a duty to the tribunal, not to the party that named them. We're all familiar with that stuff. So Klaus Sachs reasoned that, okay, if that's the case, you've each appointed an expert in whom you have faith, or several experts if there are many fields. Now that you've appointed them, they're mine. They don't talk to you anymore. And I will talk to them, and I will ask them questions, and they can't see you anymore. And I hold even to the point that we'll see where we keep the money in a place that is dispensable. Anyway,
Yeah.
why it hasn't been followed?
No, the Sachs protocol, but what happens in construction nowadays, and increasingly so, they tell you, okay, basically, play with your expert as you wish, get the reports and whatever. We go to the hearing and then ultimately say, okay, you've done your part, we've heard, received the expert reports, the cross. Now they work with the tribunal in confidence. You only get an invoice and pay for the bill. You don't know what's going to happen behind the scenes.
Have you seen that?
Yes.
Often.
It's now increasingly happening in big cases.
Well, so maybe Mr. Sachs had some impact. I mean, it's not the whole way.
Not the whole package, but at the end, yes.
Karina
Yes.
Albers, independent international arbitrator and chair of the Ciarb London branch. Following straight into that, we had an interesting debate. It was one of the last event before the summer break from the London branch. And the debate was about, should every tribunal have an expert in it? At least one expert. And so the debate was very interesting. And of course, the question was phrased, should, and not, would it be recommended? What would your view be on that?
In what cases?
In international arbitration.
Any international arbitration. Why?
It depends whether it's you can have legal experts. So most of the arbitrators are legal experts. But if you have construction cases, should you have an engineer there or a construction expert? In financial cases, should you have a banking expert or a derivative expert?
And I think the question for everyone to follow is that you would have a member of the tribunal who has this hat.
Yeah, should the tribunal...
So, because I thought you're getting an expert.
No, that's why I said we had the debate, should every tribunal contain an expert?
It's interesting.
Or would you prefer, perhaps to help you also a little bit, to not make the question too
help me a lot, please,
because it's a very provoking one. And the debate was very, very interesting, and I'm not telling you the outcome yet. Or would you prefer that tribunals should more often appoint their own expert? Because I don't think it's been done often enough.
Yes. I think I see a great difference in the whole field of experts on the one hand and legal experts on another. I mean, everybody's done the bien en route now. So why do anybody who's sitting on the tribunal should be well, if that arbitrator doesn't have expertise in the applicable law, there's been an error in the nomination, and that party just has to suffer the consequences as far as I'm concerned. But
sometimes the party wants to distance itself from the applicable law, so they appoint someone under that perception.
Yes. Not unheard of.
Yes.
But so do you say? Do you think it would be a good idea that one of the tribunal members is an expert, or would you think, as I say, should tribunals more make more use of as I say, appointing their own expert as a guidance in
Here's
complicated cases.
and something which interests me in the country where I live. In Bahrain, many commercial disputes are decided, even at first instance, by a 3-member court. This is Bahraini courts. And 2 of the members of that tribunal will be titular judges. So they're all-purpose judges. And they have to be citizens of an Arab country. That's the constitution. The 3rd one is called an expert, but sits on the tribunal and votes like one of the 2 judges. So one judge on the expert can outvote the 3rd person who is a judge. So they're really functionally entirely equal in terms of their authority. And the idea there is that sometimes there are complicated. Bahrain's the leading part of the economy now is banking and finance. There are complicated questions of financial structures which the titular judges might not be fully conversant with. So that would be a good time to appoint the 3rd effectively judge. It's an interesting idea, and I don't know, I've never seen that anywhere else.
Yeah. Now, let me ask you this to probe it a little bit, because I think you need an answer to your question there. What is the purpose of getting an expert in the industry there? Are you expecting them to be there to understand the issues in dispute easier or better, or to use their own technical knowledge on matters that have not been discussed or pleaded by the parties?
No, they can't, very simply. Okay. So full stop. So they can only make a decision and fact-finding on what has been presented before them. So it's very clear that they can't apply their own knowledge. But what they can do is, in fact-finding, ask...
the right questions.
I would try not to say the right questions, because I would not undermine anybody else on the tribunal asking the right questions. Yes. But deeper questions, and get more deeper into the actual fact finding, so they can reveal more. Okay. It is the way they ask the questions, yeah. I think.
Just as a comment.
Yes.
Sorry. I think there's a danger of delegating the decision-making process to that expert.
Yep.
And that is a complaint I've heard in a number of countries where they, the tribunal may be academics in law, and they delegate to an expert and just follow the outcome of the expert with a rubber stamp. One comes across this reasonably frequently.
Well, in many countries, the truth, I think, is that many judges are not highly paid and extremely overworked. Extremely overworked. The budget of the Ministry of Justice is just not adequate to the task. And they don't have time, so this is convenient. Expert, okay, fine, all right. How would you come out?
Yeah. No, in some countries as well, what happens is the case, which could be a legal question, the whole file is transferred to an expert of the court immediately. The expert prepares a report to the court, and you can go from there to just sign off, rubber stamp, or whatever, but it's just a possibility. You have another question?
All right, we have another question online. Can you comment on the paradox of the increasing criticisms of arbitration publicly, and yet at the same time its continual growth in use worldwide?
Is that a paradox? It grows, and therefore creates more controversy, and therefore is more criticized. I don't think it has anything to do with its popularity, and I don't think it's all that popular. I think it's inevitable. Nobody's invented an alternative.
I was going to say, no alternative, really, yes. So, yes, Svetlana, and then...
Thank you. Earlier in your keynote speech, you said that the arbitration is not designed to be comfortable. And just to add on and expand a little bit Athena's questions, you also said that before sitting in an arbitration, the counsels need to read the playbook for preparing for arbitration, but doesn't it all begin with the playbook for preparing the contract? And isn't there a chance that one comes with a brilliant idea to put together a Bible that addresses all the clash of laws, comparative, all the clash of institutions, and the clash of culture, and we all start from there, or we are running a risk to turn arbitration to a very boring place? After all, everyone comes in comfortable with what they've put together. I've seen numerous times contracts which have arbitration law on one side, as we all discussed during the course, arbitration procedural law, substantive law, so it clashes all around, seats, places, venues. Any guidelines that somebody has contemplated in preparing?
To compile all that.
To compile all that
Jan
and
can
help.
comment, but let me ask you this. You're assuming a number of things. First of all, that is a very static, linear exercise, that whatever you do will stay unchanged and no variables whatsoever, assuming you can do it.
No, if the
Secondly,
Constitution changes,
sorry?
every Bible can change as well, so it gets updated with the laws.
I'm not sure that's manageable, but yeah, I think. Or desirable, even.
Or desirable, that's what I'm thinking, whether we're not going to turn arbitration into a very boring field in this case, because everybody will feel so comfortable, so they would rather go to the courts, excluding the confidentiality of the arbitration. So that
But what are you suggesting as an innovation?
Maybe somebody sitting together with a group of people and preparing a Bible for how to put a contract which makes a party comfortable and ready to go to an arbitration. As you earlier said, arbitration is not designed to be comfortable, so how can you avoid that? What can be improved?
I have a good friend who recently retired after, I think, 25 years working as an in-house lawyer in a major international company that has lots of arbitrations. And I was asking him how he thought his corporation would react to a proposal that I had in my mind for something that could be done in arbitration. And I explained the proposal, and he said, you've got to be kidding. That took you 10 minutes. In my entire career with this major multinational corporation, the rule was, if you get to the arbitration clause and you want to change what's in the draft, you have 90 seconds to explain why to the executive who's doing it. And he's probably right. These large multinational corporations have different ways of confronting this problem because they're you would think, the frequent users or those users who have very large stakes in arbitrations. But those two categories are extremely different. There are major multinational corporations who have billion-dollar disputes, but not very often. So they don't build up this internal know-how. They don't see the need for these Bibles because this is sort of a terrible accident that happens once every 10 years or once every 5 years. You have you can think of the examples of it. You have other corporations that are selling industrial installations, and there are arbitrations every single month, and they tend to have a very routinized approach. They use the same lawyers all the time. They insist on their standard contracts and usually succeed and so forth. And they have something very much like what you have in mind about the way they approach it and their understanding of arbitration, including some arbitrations aren't worth working that hard at. And win some, lose some.
And there's one element that I think you're missing. It's the interest-based analysis that is unique. I call it like a fingerprint or a biometrics for every contract. Even if you have a template contract and you're trading places, it changes. The whole dynamics, the risk allocation, the analysis, the interest, it may vary. Not only on the basis of you changing from being the buyer or the seller, but depending even on which jurisdiction you're buying and selling. So it might be difficult. I think you need just to get a good counsel to help you with the drafting, understand your needs, and that's it. And there is, at the end of the day, there is no human product that is quite perfect. There's always imperfection. Mercy?
All right, so this question is there a clash of cultures or just a clash in the clash between EU law and investment arbitration?
This is a contradiction of positive law. third category. Easy.
Yes, I was going to say, neither a clash nor. Okay. Any further? Lucas, yes.
Thank you, Professor, for being here. I'm one of the diploma candidates, and I would like to ask, for the sake of all of us, what is your opinion? What would you recommend for practitioners who want to pursue their career in international investment arbitration, international commercial arbitration?
Which one?
Yes. Sorry.
International commercial arbitration. Yeah.
International commercial arbitration. What? Be more specific.
What would you say? What it takes to succeed if you want to pursue the career in international commercial arbitration, besides hard work?
I think this has now been understood. There was a time, one generation ago, that, well, this won't help you because everybody's figured it out. So all the competition will do the same. There was a time, as I said, where young lawyers who aspired to a career in arbitration would take every course on arbitration and study arbitration. And that was not a good idea. They should have asked for some advice from people, actually from partners in law firms. No, there will come a time for serious, hard learning about arbitration once you're at the job. What I think is required in those years when you're studying, but this is at a younger stage, to really be interested in the fundamental principles of law. And I don't mean regulatory law, the fundamental principles of law. And somebody who's thought a lot about that will have the adroitness of mind to make an impression on anybody, and everything else takes care of itself. And if you've done all that, you're a hardworking person, you will do the hard work to get up to speed on the relevant regulatory issues that arise and so forth. That doesn't help very much.
Yeah. Thank you.
Shall I ask mine? Yeah. Well, we don't have time. I don't want to impose. Please, one of our alumni as well. Mike, do we have the mic? Sorry.
Andrew Tetley, Reed Smith, Paris. Thank you very much. I very much enjoyed this talk and the discussions. My question is linked, I suppose, to the question of how harmonization has occurred in arbitration over the years, but a blind spot where I'm not sure what the solution is. We've seen in arbitration this trend towards parties and stakeholders understanding each other better despite the culture clash. Understanding each other better despite culture clashes and everything, because the soft laws, talking to people, the practice, it now works in differently to the way it did 50 years ago. And we still have certain types of arbitration which have their traditions and their ways of doing things that, operate differently. Trade arbitration's not the same as LCIA, etc. But what about the tribunal members, the arbitrators, who move between different seats? Of course, now this happens a lot more than it did before because we're more and more aware of arbitration internationally. Picking seats, it's not just London and Paris now, or Stockholm. There are seats being grown up around the place, and we see these institutions being developed in various countries to try and promote arbitration. Seated here, seated there. And the arbitrators, who are then asked to go and sit in some seat. I'm not going to be specific about countries, but there is a much bigger, and looking forward, surely this must happen more if arbitration is to continue growing. We will be asked to sit in more and more seats around the world. The harmonization of the regime that governs the arbitrators' liabilities as you move around as an arbitrator in this new world. Is there something that can be done here to harmonise this? Is it something as an arbitrator that you think about as you're asked to go sitting here, sitting there? To take the recent example, Hong Kong has just had its Court of Appeal hand down the decision to confirm that, in Hong Kong, despite everything that's going on over in that part of the world, it is judicial immunity, essentially, for arbitrators. In France, the standard is different. In other countries, some well-known, one is very hesitant about sitting because of and this has real, I suggest, real impact, but you tell me if I'm wrong on this, on how the arbitrators are going to behave. Because if you're in a jurisdiction that has quasi-judicial immunity, the arbitrators can afford to be, if I can call it this, more bold in the way they deal with procedural issues. And if you're not, maybe they aren't. But do you think about these things as you sit around in various parts of the globe? Is there an unconscious bias that operates, or a conscious bias that operates on arbitrators as this happens? And is there a solution in the terms of, for example, if there's we've got the New York Convention, but if you had a uniform standard, elevated everybody up in the world who sat wherever they were to quasi-judicial immunity, is that something that's something to think about, something to aim for? Is it something that, or not worth doing? That's my...
I don't know. There are, I think in most, it's so rare that an arbitrator is pursued for misdeeds. And occasionally one sees cases in which the arbitrator absolutely deservedly deserved to incur liability for intentional wrongdoing. But you have to, there are places in the world where you have to be a bit nervous depending on the kind of case it is. Not so long ago, I won't mention the country, but there was a country run by hereditary rulers who, and having a ruling family, where an ICC arbitration was held in a business contract involving a member of the ruling family, adverse to the member of the ruling family, whereupon 3 arbitrators, unanimous, who had done this, were indicted for, I don't know how it could be defined as crimes, leading the president of the International Chamber of Commerce, quite serious, because that means no travel to that country by those 3 people, unless they really want to surrender. I don't know if it was really imagined that they would be locked up. That country is part of a regional grouping where judgments are enforced, so that expands the scope where you'd be nervous in going. It's rather dramatic, causing the president of the International Court of Arbitration to write to the ruler of the country, saying, is this the reputation you want to have? No answer 3 years later. So that kind of place you might be concerned with, but depending on what sort of a case it is. And you see maybe the name of one of the parties will give you pause, and you'd rather not do that. But I think, Mohammed, what do you think?
I think, again, it goes back to the standardization. And then you have now, I think, look at today's world. We talk about globalization, but you also see a rise in nationalism. And we tend to loosely use terms like tradition, culture, social behavior, social practices, without delineating the differences between each and every one. And if you sit on a table, it's easier for us to sit in a room, in a beautiful garden in Oxford, saying that you can standardize and harmonize. Well, you sit with decision makers, different governments, it's a totally different game. There are political positions behind that. There are economic considerations, social considerations. All these play together. And then you will come to the question, who is in a position to propose what and be heard and taken seriously and be accepted by the other community of states? It has been done. I mean, CISG, as Jan has mentioned, has been very successful. Noting, by the way, who do international law, that is one distinct convention with substantive provisions. Many conventions deal with either procedural or international cooperation. This one has substantive provisions. Why? When you look at it, because there was a uniform common interest in trading on predictable and clear standards across the globe in a way that helped this type of harmonization in a sense. And yet, you see today, despite the fact that you still have case law interpreting the convention, every now and then in some jurisdictions, a judge would construe it differently. So you have this, and you will continue to have it. The question is, where do we want to go from here, right, forward in relation to our practice and our humanity, by and large?
And right there, make the observation that no acceptance of the CISG seems to be impeded by a class of cultures.
Yes, absolutely. Yeah. Yes, so we'll take a couple of more questions. Please, you go first, and then, yes. Okay, 3 more questions. Okay.
You're probably...
It's not every day that we have Jan in person, sorry. Yes.
Peter Fields, I'm with the Barrister Group, English Barrister. You're probably aware of the Law Commission review of the English Arbitration Act, which is just completed, and one of their recommendations is to give an express power to arbitrators to make a summary dismissal of a claim. And the balancing view was, well, they already had that power because they got a duty to act expeditiously, and that runs into the problem of what they call due process paranoia. There's nothing more to my question asking what you think, whether you think this is a good thing or a bad thing to have the express power as the English Arbitration Act will now have, or is it not necessary?
I think it will, any apprehensions that might be held in this regard will dissipate over time as it comes into effect. Somebody will say, a respondent, when I agreed to arbitrate in London, that wasn't the rule. And this is, I take it, a rule of curio law rather than substantive law, and I wouldn't have agreed to it. So you see what I mean? With time, that particular objection will dissipate. So I think it's good power for the arbitrator to have, to be exercised very rarely, but it's a nice threat.
I agree.
Yes? Yes, thank you very much for the very engaging presentation. I'm an in-house counsel, so I'm the least experienced person probably in the room on arbitration, but I am a customer. And after Dr. Mohammed's lecture on the various laws to use in clauses for arbitration, I ran back to my room and checked our trading clause, say, what have I missed out? And luckily it was okay, but then I looked at, but just by pure luck. But then I looked at all the other clauses, the recommended model clauses from all the different arbitration authorities, and they're different. They're different. Some of them miss out stuff that Dr. Mohammed had told us. I mean, isn't not a Bible, but isn't the least that we can expect from arbitration authorities across the world to coordinate a bit, to get a sort of model clause at least that poor in-house counsels like us can use and not fall into traps?
Indeed, yeah. Interesting.
Yes.
I might, last point for me, we have 2 more questions, but last point for me, a little anecdote from the 7 years that I was president of the London Court of International Arbitration. I'd be rather often in the offices, and one thing about young lawyers who work in arbitral institutions is that they tend to be nicely competitive. They want to be as good as anybody working in any, they want their institution to be as good as any other institution, and that's the way it should be. And one day I was walking in the halls on Fleet Street of the LCAA, and I heard 2 assistant case managers discussing a case, and they said, the award came down in such and such a case that you were handling, right? I read it. So the one who wasn't in charge of the case had read it. So they're taking interest in everything that happens. And said, it's really good. It's really good. So I said, hold it. Just, I was behind them, and I said, stop. What is a good award? 3 things. When an arbitration drags on and takes too long and arbitrators extend deadlines, who does the disgruntled party call? The arbitrator?
The institution.
One of those guys.
Yeah.
That's a good award. It was on time. The arbitrators didn't ask for more money. Who does the irate party call when the arbitrators who have given an estimate for the case and now they want more money? The arbitrators? No, they're going to decide your case. Calls one of the young. And the third one was, it makes sense. I like that. And I thought about something on the spur of the moment. I said, by the way, tell me a little bit more about that case, in case I remember it. I wouldn't remember most of the time. And I remember the case, and I said, isn't that one of the cases where the court appointed all three arbitrators? No dissenting opinion, no funny business, no. Just an anecdote.
A couple of more, and we finish.
Yes. Thank you, Professor, for your words. In terms of diversity, which is an important topic not only in our industry but in the world, on the one hand, we see some movements. We see in the U.S. for a second time the presidential election, going between two white males, right, for a second time in a row. On the other hand,
not diversity in arbitration.
No.
Okay.
No. On the other hand, we see, for example, many companies and many boards, having to switch or twitch the board members or their leadership, just so they show they have a percentage of minorities or diversity in their companies. Not necessarily being the best people in the board or the best people in the leadership, but that showing that there's diversity. So my question is, how do you see the industry going forward to have a proper balance between diversity and quality in international arbitration?
Repeat your last sentence.
How would you see the arbitration industry or the community going forward in order to reach a good or proper balance between having diversity in the industry and having quality in the industry?
Why are you putting them as extremes, as if there is a tension between diversity or inclusion and quality?
Sorry?
I think he wants to strike a balance between diversity on one hand and quality. That is his question.
Well, I refuse to believe that it's necessary to compromise. I refuse to believe. And now I will say, now I will say one thing which is very politically correct, and then I will immediately say something for which apparently I can be shot. I utterly believe in diversity. That was the first one. All kinds of diversity.
Yeah.
Sorry.
Yeah.
I think the answer is you will have more quality if you have more diversity. That's my...
Yes. More insights, more ways of looking at it. I've seen...
variety of answers and all.
Louis.
Oh, one?
Yes.
Maybe looking at a little lake of young people, I say, if there's one thing older arbitrators don't particularly look forward to, is another case sitting with two older guys. Sorry.
Louis.
I'm going to flatter you for a second time. I can't believe it in one day. I learned, I must have been about 12 years ago, that one day Jan was appointed as a co-arbitrator in a case where David Hacking was the other co-arbitrator. And I know this because David told me.
Oh.
And the two of you got together to decide on who should be the chair. And you came up with the idea of having somebody, A, from the opposite sex, and B, who'd never sat in an international arbitration as chair ever, so would be given their first break. David agreed. Now I know who the chair was in this case. I have applied this 5 times since. I have phoned up my old grey opposite number and said, there is no way I'm going to accept an old grey male middle chair. It's not going to happen. What do you think? And he said, who have you got in mind? And I would give the names. And I've done it 5 times with no dissent at all, and it's been hugely successful. It's a tiny contribution to diversity, but you sowed the seeds of the idea.
You see, in that case, which I remember, the person we appointed to chair us, it was a very significant case, and it's one of those cases you really want to be involved in. It's very, very large and interesting in all ways. And the presiding arbitrator was, I think, a quarter of a century younger than either one of us. But it was somebody that I had known in 2 firms back in her career to be somebody who was extremely applied in her methods and having good judgment. I just had no hesitations.
Well, we'll finish here, but I will say one thing because I'm tempted. This is a striking example where I think, and we can take and discuss that, where certain cultural practices matter, because in certain parts of the world, sometimes elder or much older people will take serious issue being presided by a younger person. And I know they may not dare to speak in this room, but I'm telling you seriously, that happens. And that culture needs to change, or that behavior needs to change in a way.
Those people are no fun. Why would you want to sit with them?
But imagine, no, seriously. But I think we are spared in a way because we sit in our international arbitration. Normally, these types of practices you don't see. But there are very, very interesting practices worldwide. Now, what remains is simply to thank Jan for his time and for giving us all the insightful questions that have been with us today. To thank, of course, all the Ciarb staff who've done a formidable job and continue to do so, and merci also for managing our online people and people who are commenting and asking questions. So our thanks also to those who are online. Our alumni who are joining us today on the diploma, can I ask you just to stand so that we celebrate your presence? Those who are past alumni. Thank you.